we just kind of want to
Yeah.
be pretty relaxed here and have a nice
Okay.
little chat. So we'll start with basically it's February 11th, 2002. We are here in my Santa Monica office to do the oral history of Carl Huranke on Colorado River Matters. I thought, Carl, maybe we'd start with a little bit of you telling us a little bit about your personal background, where you were born and education. And uh, I think your first job was with the California Attorney General's office. Maybe you could tell us a little bit about that, because I think ultimately that led to some of your involvement in the Colorado River issues, because that was part of the AG's jurisdiction or oversight of the Colorado River Board.
Yes, that's a very interesting point. My education was in New York until age 12, and then in the public schools here, including UCLA undergrad and then UCLA Law School, from which I graduated in 1954. And I went into the Army for almost 2 years. And when I got out, it was at a period where the public offices were hiring. They hire like once a year, and I was 6 months early. And so I did have another job with an individual or solo practitioner for, perhaps 6 months, not more than that. It wasn't anything that interested me terribly, general things. And I was drawn toward the issues, public policy issues, and the importance of cases in public law offices. And I applied to 2 or 3, and then when hiring season arose, I had choice between the United States Attorney in LA in antitrust work and the Attorney General. And I liked the broader scheme of the Attorney General's office. And I had some friends there who I'd met in the Army and others who I went to law school with. So I went there, and there I had a series of assignments. Most new attorneys start in the criminal field, criminal appellate work for a couple of years, and I did that. But to get out of that, in those days it wasn't. This was the late 50s. It wasn't as exciting. There were very few defenses like Miranda rule and this and that and Fourth Amendment things. So it was cut and dry on those cases. So to get out, there was a big water case, the Santa Margarita water case in San Diego County, being tried by Adolph Moskowitz of the Sacramento office. The Sacramento office was the seat of most the experienced water lawyers of the state. So I was interested in water at law school, although we only had 1 hour lecture on it. So I joined Adolph as an assistant, literally, doing, to a great extent, grunt work, but attending trial quite a bit over several months. So I got more and more interested in water. But that ended, and I did administrative law work and other work. But one assignment came along was the Colorado River Board. And there I learned a lot about the Colorado River and also met a lot of people that later on were important in my life and career, since Metropolitan had a strong contingent there at Imperial, and as you know, Karen, all the contractors in Southern California, water contractors with the federal government. And then also you met people from other states who had interest in the Colorado River. But that was just sort of a passing phase, and then I got into other work.
So was there a period of time when you actually sat with the Colorado River Board
Yes.
as their attorney?
Uh, I was never the Colorado River Board's, oh, let's see, that's not true. Yes, I was the Colorado River Board's attorney. Yes, that's so for, while I was in that field, I would attend as their attorney.
Was that like in the early 60s or?
It could well have been the early 60s. I'm trying to think of some major thing that could have happened that would give me a better handle on the years. And
Well, I would imagine.
I remember also that I didn't sit as their attorney for part of it, but sent Jane Goichman there because I remember her telling me about things. So she was there for part of it, but I used to attend some of their meetings. I remember how it started with Mike Ely. Mike Ely had been a special counsel to the Attorney General. He had a card published that had his name, Special Assistant to the Attorney General, and he had that in connection with the Colorado River case going back to the 50s, that was tried sometime in the 50s and perhaps 60s, but certainly the 50s. And he came in to see me and said, I'm your new partner, and things like that. And see, I was totally new to it. So at that time, I must have been the counsel for the board.
So do you think that was before the court's 1963 decision, or was that after the decision had been rendered?
I'm sure it was after, because I was at the office when the decision was rendered. Firstly, I knew of the other group of attorneys that were all regarded as deputies, but special, perhaps a dozen, working on that case, and they weren't housed where we were. But I knew of them, occasionally came across them, and Jerry Mize was one, and Howard Friedman another, and I think John Alexander. There are a lot of, I believe, Norris came an appellate federal circuit court judge. I think he may have been on there. There are a lot of Stanford people, and Charlie Corker was a professor at Stanford, was in charge of all that. But they weren't housed with us, so I didn't get to know them at that time, though just occasionally some would be over here or there. But it was after that decision came down that I became involved. I remember the decision coming down, and we all got a copy, and there was a bit of a debate whether we won or lost. I think it's pretty evident that we lost after I got into the Colorado River litigation.
What was the rationale for those who thought California won?
Well, we got 4.4 million acre feet. There was this group, and they had sort of an attaché, but in practice, but his name was, I think, Gilbert. But he was really a senior career AG person, and given to them because he knew the way around. He knew what had to be filed in the Department of Finance or with the controller, or how to get people paid. So he wasn't necessarily a water lawyer. I'm not sure he was. And they didn't hit it off well.
Mm-hmm.
So after that case was over, he came around and handed out to all the deputies, myself, who weren't in that field at all, a sheet of paper indicating that we turned down what would have been a generous offer of settlement, and that in his opinion, had we defaulted, we'd have been better off than the judgment that the court rendered. Well, that's pretty heavy stuff. And I'm in shock. I could just see that, and Charlie Corker is having a meeting of everybody that afternoon explaining the positive side of that case. I don't think I ever heard him say we lost that case. I had great admiration, respect for Charlie, and I got to, and he eventually took over the Attorney General's office in Los Angeles under Stanley Mosk. And I thought the world of him. I mean, he was a very interesting, brilliant, eccentric fellow, but very enjoyable. But that's the way it was. So that all died away, and they went into legislation to confirm the 4.4 to give it priority. Then they felt that that was a wonderful thing.
So these were all the legislative efforts on authorizing the Central Arizona project and making sure that California's 4.4 had priority.
The priority, I don't know that it, I don't know that if that legislation covered Central Valley. I just don't know that. I know that Holbert was by then on the Colorado River Board as its executive officer, chief engineer, and that he did a great deal along with Mike Ely in getting the legislation through. The huge disappointment, as you know, in the initial case came from the fact that California assumed the whole system of water was available and we'd get a share because the system wouldn't have been used totally by all the other states. And the Supreme Court said the allocation referred to mainstream, and that cut back the excess water that would have gone to California. So I vaguely knew that. I heard more of that at Met than I did. I didn't hear anything about that at the Attorney General's office. But at Met, I came to understand why they went the way they did. But I'd say one more comment that I hope is getting too long in this. In retrospect, you can't help but see Arizona as the widow and orphan. And yet at the time of the trial, California dwelled on the merits, the legal merits, and they were strong in favor of California. So the California position was a bit unbending. They relied heavily on the law, and I think if you work on something, you can get blinders and be convinced. And I think they were correctly convinced of the law. But the way I see it, if they looked at the bigger picture, they would realize that there would be great sympathy for Arizona. So if you gave the court a chance to do something for Arizona, it would, because of its inherent sympathy, similarly to Indians or other underdogs, unless things are just not, I mean, just arguments are too strong to modify. If a judge has a chance to help the party who has the sympathy, he will. And so I look at this many years later and say, Arizona is landlocked, and Colorado means a lot to it, and California looked pretty good. And so I might well have urged, if I were in a position, a settlement. But Mike Ely's disposition, I think, was against that kind of thing. My dealings with Mike, maybe he settled lots of cases. My dealings with him, whether we were together or opposed, and we were opposed on a number of occasions, was one of unbending warrior. he liked to use the terms, "we'll meet on the plains of Philippi." You know, he liked to stand toe to toe. And so if there were a compromise, it was way in his favor. But you had the impression till the end that he really preferred to go to court. Well, to that extent, he was hugely disappointed. I will say for him, he thought he won the case. I think it was Justice Jackson that may have left the court after the argument. And then a new judge was appointed. And then they instead of just handling it, they allowed another argument. And Mike told me that he had learned through sources that the vote was in our favor initially, or would have been in our favor informally, and that he lost it just the happenstance of a judge leaving and a judge coming on in another argument. Well, that's probably more than you want to know about that, but eventually I got into public resources in the Attorney General's office. I became in charge of that, and that included, again, the Colorado River Board, as well as the Coastal Commission, Fish and Game, Lands Commission, and Agriculture, and lots of things regarding that broadly put under public resources. And it's in that period that I got to know the people from Met better, particularly Bob Will. And after 5 years in that field, he offered me a position as his assistant counsel. So I came over to Metropolitan, and just a different world.
Tell us a little bit about the period, though, when you were overseeing the public resources section of the Attorney General's office.
Much of it was writing opinions for various commissions or agencies, including the State Water Resources Control Board and the Department of Water Resources, as well as the Colorado River Board. And there was new hazard waste requirements, and perhaps the biggest thing going on was the new Coastal Commission. That took everyone's attention in the office. When I say everyone, in my unit, but my unit grew because of that new work, and a lot of people, very bright people, come to be interviewed. They wanted to get into that. Coastal Act at the time was very favored by the public, and that influenced the commission members very, very much. And so a lot of my time was given to that because we had older people in Sacramento that wrote opinions for Fish and Game or for the Department of Water Resources, or handled trials on water quality by the Water Resources Control Board. And similarly, in San Francisco, there were some older people as well as a lot of younger people. And LA had a lot of younger people, all within public resources, I refer to. So I had to spend much time, though I was in charge of all three offices, and indeed eventually San Diego office too. I spent a lot of my time trying to create a uniformity of decision. There are several coastal commissions as well as the state commission, and I'd be having to talk to each attorney each night after they've had or before they've had a meeting on what we anticipate would come up, what is coming up, what our position is. Well, in San Diego, we said thus and so, and in Sacramento, so we tried to get some uniformity of opinion on very new law. And so a lot of my time was there with young people who were very, very bright, and I never told anyone to stay late or anything like that. They just worked because they were so enthusiastic about what they were doing.
So this is probably in the early 70s?
Yeah, because the act was 73, I believe. The initiative, I think it was an initiative,
Right.
So that was the Coastal Act of 73. I was aware and kept in touch with everything else going on because all these opinions I have to read and approve. And some of them I found were 2 years old when I got there. There were 2 years of bickering between attorneys on points. I mean, it was just not done in a prompt manner.
About how many attorneys were in your section, your unit that you were supervising?
I'd say 35 at the beginning, maybe 40. But there are a lot of positions that at any one time aren't filled, so I'm not certain.
Well, around the same time, I guess another big issue, I don't know if you dealt with a lot, would be the beginnings of the Endangered Species Act. The federal act, I think, is 1974 or thereabouts, and probably Fish and Game. Some of the agencies that you represented would have great interests.
Yes, and you have the beginnings of an interesting conflict there. Eva Younger, I believe, was the Attorney General. I think Eva Younger was the Attorney General, and he created an environmental unit which didn't represent anyone but the people of the state. Like there's a lot of laws, charities, and antitrust, I think, where there's no client agency, but you represent the people of the state. Attorney General is it, so to speak. And so he created an environmental unit, and they'd be suing my clients. Saying the Endangered Species Act, where they just grabbed that and they would try to stop dam building, this and that, the other thing. And I was the attorney for these agencies. So we had to work out things. Either we worked out something in the office, or, a lot of things happen before any litigation is considered. So it became more and more obvious that they'd call me and say, they can't finish this dam at the last dam built up north of New Melones. See, they can't put water in it. It was done, but we're not going to let them fill it for this reason or that. And so we'd have to work out something in the office as to which way we're going. If they were going, then I would remove the Attorney General as representative of the agency and tell them they have to hire their own attorney. Or I would convince Eva Younger that these people should be tried by environmental groups. There's no need for our group. We should be in areas where we make a difference or where no one else is there. But if you have the biggest environmental groups suing that we shouldn't deprive the state agency of legal services because of this other unit. I mean, they're plenty busy. They have other things. They didn't like that. They always thought they're the best one. Rather than the other environmental groups. I mean, they wanted to be there, and they did. They did a great job. They did that. Mammoth Lakes case they filed an amicus brief that I think won the day in that case, and people wept over that. I didn't have. I didn't allow personal feelings. I truly believe I never have to come into any of my work. I would defend the Coastal Commission when they allowed a big hotel right on the beach, if that's what they did. That's it. I may have personally thought it's a terrible thing, but that wasn't my job. They didn't hire me for my view. But I certainly and the same thing would happen with these agencies, whether building dams or water quality, where no one cares about my view. I mean, they may care, but where they acted, I defended them. So that Endangered Species Act created a real problem in our office. And sometimes we were able to represent the client. Occasionally, we weren't.
If you had to declare essentially a conflict and not represent the agency, then did the agency have to go out and hire
Yes.
outside counsel?
Yes, occasionally they'd have, let's say the Department of Water Resources, for example, has its own legal staff. They don't go to court, but they could.
Mhm.
And so in their case, they would go to court. Other agencies might have had a single house counsel that wasn't equipped to handle it, and they'd hire. And still other cases didn't have any legal counsel other than the Attorney General. So they'd have to hire. And that meant a problem because they hadn't budgeted. They budget only once a year. So whatever wiggle room they had in some of their other budget items, they'd have to use. So that did create a problem. I was more on the other side of endangered species, having to argue that it didn't apply in a particular case because I represented the client that
Mhm.
that was being attacked. I think in New Melones, these people chained themselves in the bottom of the dam to some tree. And, well, winter came and I think the floods filled it up. It became a moot point.
Did you work on the New Melones case with relationship to the water rights and whether the Bureau, the federal government had to come to the state to acquire their water rights?
Yes, I worked on it, but it was Rod Walston's case. One difficulty with being in charge of 4 offices and a lot of people is that you really see these wonderful cases come by and you can't handle them. You have to assign them.
Right.
So Walston was the top man for that. I mean, I found that out quickly. And so he would handle it. Also, it may have been in his area. New Melones is around the Bay Area, so it probably was his area. So I worked with him, but he had the laboring oar and won a remarkable victory with that case, saying they were subject unless it's clear in the in the congressional statute that they're free of state law, then they have to comply. If it's possible, they have to comply. And interestingly enough, they referred to Arizona versus California as the kind of case that shows the federal government has superseded everything. And yet there was a time later when I wanted to argue that the urban areas have priority over rural areas or farming areas in water disposition when there was a shortage. The urban areas under California law are first. And I would say on the Colorado River. And I asked Walston about it. He was in the Attorney General's office still. But we chatted about it, and he says, well, but the Arizona case is the one that illustrates when the federal government. But I said, that's what happens when you're just, over the dictum, when you're illustrating something. You didn't have in Arizona, California, that question of urban farm priority. And so even though they said it generally, that doesn't mean they can't find in a particular matter. But we never got to trying that case. Firstly, he did point that out, and I made what arguments I could with him, just trying to convince him as well as myself. But we never got to that point. I always felt that was a point that someday should be brought up, but it had to be brought up in a context of urban areas suffering. And I don't mean people just being without water, but with industry closing, with jobs being lost, with tremendous economic trauma. Then you're more likely to get a court to say, well, surely you can comply with state priorities without destroying the federal run of the river. And so that is okay. I mean, the fact that you say the statutes authorizing Hoover Dam and the rest on the Colorado River were portrayed as showing what you have to do for the federal to supersede state jurisdiction. That didn't mean there wasn't any variation possible, but you have to overcome something, so you had to wait for the right context. We didn't have the right context. I wanted to use that in bargaining. I just brought it up for bargaining.
Mhm.
I wouldn't have gone to court with it under the context, though I was starting to get there with the 80s drought.
So you probably started thinking a little bit more about it in the context of the State Water Resources Control Board waste of water hearings with IED, and it kind of all ties into the application of state law versus federal.
Yes, and that's an extremely interesting point, because when I went over to Met from the state, the hard and fast rule was we don't want the state to have anything to do with Colorado River water. It's all federal. We're happy with federal.
Was that
That's
as much a legal position as a sort of a political one that there was?
It was, you can't divorce them at Met, and maybe you can't divorce them anywhere. But the legal department certainly, took Arizona versus California and the new Malones case, referring to it as indicating, well, that's where the federal government has superseded, clearly in its language has superseded state law. And they were happy with that as a matter of policy and as a matter of law. And we didn't even, no one wanted to think about that. The concern at Met, of course, was that the state was less certain. We couldn't anticipate what the state would do. We didn't have the power in the state that we felt we had with Colorado, with the federal government on Colorado. We just didn't feel Southern California in the legislature was strong enough, and we didn't know what governor would appoint who on the Water Resources Control Board. So for a lot of reasons, we just kept that out of their hands. I mean, that was a firm position, and I just accepted it as it rarely came up. But when it did come up, I went the other way. And I said, we haven't thought that through for a long time. That's just something, there are a number of things I found at Met that we did because we used to do it. And it worked. And things had changed, and people weren't as aware of the change. Different politics, different people leading. I mean, we used to have people from the South that were very important, Carly Porter and Lanterman and some others in the legislature that were major water figures. And we had no one for years. They were all Central Valley people. We hardly had a person on the committees, the water committee in the legislature, and they were not turned out to be very unreliable. I mean, they were with you, and then they trade their vote for something they wanted in inner city schools, and that's politics of things. But it indicated to me times have changed a great deal. But the circumstances also pushed when they were wasting water as they were on a grand scale in Imperial, and a farmer sued for flooding his lands along the Salton Sea, and they were going to have hearings on it because he complained, and there's a procedure for the department to Water Resources to investigate and then present its report to the board, and then the board had hearings. We didn't initiate anything, but we participated in those hearings. We testified. I testified, others as well, I think from Met and lots of other people. And I just thought it was the first move slightly away from the position that there's no jurisdiction in the state, because they were asking the state to stop waste of water, and that meant water was available for Metropolitan. So from a practical water point of view, rather than just legal theory, it made sense to me to do that. I also started to feel that we wouldn't prevail on keeping the state out. It depended on the subject matter. I don't think the state could tell the federal government how much water to release, but I think it could tell a particular state agency how to handle its water distribution to the farmers, or to build something, or to do something not to waste water, or perhaps to fine it. Depending on what you wanted, I think the state board could mesh with the federal government, and it was to our advantage. So we did that. The board had no problem with it. I mean, I don't know if the board had the fix on keeping the state and federal jurisdiction apart, as did the top staff, who were there a long time and who just accepted and continued something that I think was no longer useful.
So you tried to, I guess, Metropolitan tried to sort of walk a tightrope in
Yeah.
the state board proceedings.
Yes, we encouraged the board. We presented evidence. We never addressed the issue. Of whether the state had jurisdiction. I think the issue was raised by Paul Engstrom on behalf of IID. That's generally my recollection. And the appellate court held there was jurisdiction. So we didn't take a position, but it came out where I thought it was to our advantage.
During this time, and I guess ultimately one of the things that the state board writes about in this decision, which I think is decision 1600 or something like that, is the possibility of water transfers and moving the water from the irrigation district to urban areas.
Mm-hmm.
Was that kind of the beginnings of ID transfer discussions?
No, the idea of transfers came even earlier in my own mind by casually reading articles by economists, typically, saying, one insane thing in California is the water in the city is worth 1,000 times what it's worth on some farms. How can you justify that? And but all of the people in the industry were in love with farms, even in the cities. They were in love with people even today. If you ask them, do you like the farm? Oh yeah, farm's great. They don't know the farmer is the Duke of Luxembourg, who doesn't farm but gets paid millions for not farming. I mean, there are a lot of things to consider, but when you read these economists, small articles here, occasionally there, I kept thinking that this is something that should change. Now, how do you change it? You just can't throw away the other guy. You buy him out at some reasonable price. If it's worth so much more to you than it is to him, there's certainly a midway point where he's happier, or that should happen. But politics and history and emotions delay that. I mean, eventually, I always believe eventually that will prevail. I've given talks like this while we were working on the Central Valley Improvement Act to farming groups, and I remember starting one speech that says, I recognize that one of the important considerations for farmers is the profit. And a farmer stood up and he says, wait a minute, it's the only consideration.
It's not quality of life.
No, he says, it's the only consideration. And no one contradicted him. And here I was kind of pussyfooting it. I mean, I was direct, but I say among the most important, he said it's the only one. That's the way farming goes. You grow onions if you anticipate, you know more about farming than I do. But I learned a lot. And so I had in the back of my mind the idea of transfers, but I'm saying way earlier than me, I'm sure Holbert and predecessors all looked at the farming in the valley and the way it was done in a wasteful manner, and it could be more water from Med. But a major problem to this thinking is that there was ample water. When there's ample water, you don't care. There is no waste. You're getting your water. That's all that matters.
So you have no basis
So
to complain.
that you can't complain. I recall reading a dissent in, I think it was, Colorado versus New Mexico, or, and the dissent said something about treating. It said, given the circumstances, you could transfer water that is a factor in allocating water. And then eventually another case talked about water as a commodity. It may have been the same case for all I know, but they talked. Oh yes, I think it was Colorado passed a law that it couldn't sell water, couldn't send water out of the state, and that was stricken. And for the first time, to me, I saw the court moving away from the concept that water is just a use right to a commodity. And that, of course, is another step toward transferring water, making water transferable, allowing an economic context to control or at least heavily influence transfers. You no longer think when you only have a use right, if you don't use it, someone else is already there in the wings to use it. There's nothing you have to give away. I also recognize that I was self-contradictory, because at all times we said IID can't sell water. From time to time, IID would sell water to a manufacturer or a thermal energy producer, maybe outside its boundaries or within its boundaries, but not for farming. And Coachella and we would always take the position that you have no right to do that. They just give us notice. They'd send a letter, this is what we're going to do. And then we'd write back and threaten a lawsuit. And they'd say, okay, we're asking your permission. And then we'd give them the permission, because it was minuscule. It was not, and there was plenty of water. We didn't like them to establish a right, but we would allow them. And this happened over the years occasionally. I saw some older ones. I was involved in some. And all the while focused on the Colorado River, since we were in the chain of getting that water if no one else used it. That was our position. On the other hand, I had in the back of my mind that the ultimate solution to limited water supply would be an open market. I'm not an economist, and I would refer to economists and talk to them. And indeed, we hired Tim Quinn from the Rand Corporation, and he's an economist and an outstanding economist. And so I had these contradictory things. They didn't come up together. I always knew in the back of my mind that I was for water transfers, but there was it wasn't ready, and so we held to our position on the Colorado River, that there was no water that was unaccounted for. I mean,
It was already
it was,
over
yes.
appropriated.
Yeah, so eventually when we had a chance to deal with IID, following the state board ruling that they were wasting water, had to make changes, and the state board was helped considerably by our testimony, saying we would bear the costs. We would contribute, if not bear all the costs. I don't recall exactly what we said at hearing, but our ultimate position was we would pay all reasonable costs of saving water in order to be able to have that water. And I think the appellate court and maybe the trial court as well referred to that there are others who would bear the costs of these water saving devices or means. And so following that case, we started up the talks with IID on improving their system.
Do you recall, did someone from IID call you up, or did Met initiate the discussions?
I think it was Met, but I'm not absolutely certain. There was a fellow named John, a pretty big, heavy guy. He graduated from, I think, UCLA Law School, but he didn't practice. His family had farms down there, and he was a farmer. I know he's the first one we met. Whether he initiated it or we did, I don't know. I think he did. Because at that time, I don't think, I mean, we foresaw shortages, as water executives always do, look depending how far out in the future you look. But I think he called us, we had lunch, and he said he's on his own, the board doesn't know it, but he thinks this is where they're going to have to go. So let's start talking about outlines of where we go. And I'm not sure the manager was there at that time or he was alone. But when the board learned of it, they just nixed it. They, I recall once they just directed the manager not to attend any meetings like that. And they couldn't say anything about a board member, but they made it very clear to him that he's got no votes. So I don't know that many meetings took place at that time, but that was the first breakthrough. But as time went on, and they had votes and maybe new board members, eventually we did get to that point.
Well, as I recall, there were actually two deals. I think there was one deal that was struck in about 1984, and I think Metropolitan Board actually had approved it, and then it went to the IID board who rejected it.
Was it that early, 84?
I think that's correct. And
yes, we had a deal. It was a real struggle. They constantly wanted to sell us water. And they, apart from the price, which I thought was far too high, they wanted to make this point that they could sell water. And we were just as adamant about not buying water, that if we bought it, then we'd have conceded the position and they could sell to anybody. They could sell to the highest bidder. And I think they always had San Diego in mind. And so we just wouldn't hear it. But we negotiated and negotiated, and they finally agreed. And I said, you're going to have to make reports to the state board showing what you've done. And it was in conservation. And so they came around, and we agreed on a number of projects, a list of more than enough, and we started out with the least expensive ones, and we gave them extra money. There was some wiggle room for them to do some other things to make it more palatable to the non-farmers in the valley. You know, we talk about IID, but the county board of supervisors and lots of city folks had to feel they're getting something, and yet we had no business building roads or otherwise helping their infrastructure that didn't relate to water preservation. So we had to do it, you know, it had to be a road that ran along a canal, and, you know, so some kind of compromises that would meet the standards necessary for our giving them money for conservation of water. And so we went and we made the deal, and they said, take it to your board first, and we did. And then their board backed away. And I've seen, you know, I went down to see them, talked to them individually as a group, and it's privately they say, you know, it just became evident. There'd be a petition to remove us, or the next election is coming up and we'd be done. And the opposition was organized and heated and constant, and they got scared off. So we wound up with I don't remember now the structure of the first agreement. I think it was changed in the second agreement, and and they had a new chairman, Lester Bornt, and he and I would talk a great deal, and he saw that this has got to happen, that there has to be conservation, and he had to have enough things there where he could sell it to the valley, not only IID and the farmers, but the valley generally. And we came around. The difficulty that I had with that was, you know, we were after 250,000 acre feet. I mean, that was going to be the first contract. I think a federal study of 10 years earlier indicated there was in excess of 400,000 acre feet of water that could be conserved. So we went for 250 and thought maybe they'd knock it back to 2, and they wanted to do 25,000 acre feet. When, after we agreed to the whole approach, then the numbers they wanted, I said, heck, it's not, you can't justify all the meals we bought you. I mean, you know, couldn't do that. So that agreement, instead of giving us a chunk of water, was regarded as the pilot project, the first of anticipated additional agreements, and it was for 50,000. We said we wouldn't even go to our board with this if it's under 50,000 with all the effort made. It's just not consequential. So that worked. We got 50,000. There are a lot of qualifications where under certain circumstances they're in trouble, they can get the water. But we thought generally it was a good start, and it was a breakthrough, and it was a major breakthrough. I got calls and letters from England, articles that said this is what should be done in Africa and Asia. I mean, you have wealthy countries or areas or businesses that need water, and water is not well handled, and it's win-win. I really don't like that term. It's so used so much about us, but that's the way they put it. I think a report in New York and in London came out saying, look, there's lots of places that this could be done around the world where you could use water more efficiently, and the poor people would not lose water, and the wealthier ones would pay and get water by this system, not the purchase of water, but improving. Now, I was never against, even at this time, the purchase of water, but on Colorado, I felt you first had to conserve the water, get it to a point where you're using it efficiently, and then if you wanted more, you could get into purchasing water at some time. I never lost sight of that.
At the, for the first ID Metropolitan transaction, the one I think was in '84, you and Warren Abbott actually did most of the negotiations yourselves, I think, which, considering that you were by then the general manager of Metropolitan and Warren was the general counsel, it represented a significant commitment of time and effort on both of your parts. So you obviously must have viewed this as a very important potential transaction. Otherwise, you could have assigned other staff and high-level staff at that.
You're exactly right. I looked at it this way, as engineers did. We had our water rights from the state project. At least we had them on paper. We were getting a lot of water, but it became more and more evident that we were not going to get all the water that we had contracted for. That was our a major source of water. The other was the Colorado River. And we had the amount of our allocation, and that was that. And this was a breakthrough for another source of water, even though it was from the Colorado River, but it was from someone else's allocation, or the way we put it, to more efficiently used water. So there would be water that would be within our rights to take. So here was 50,000 acre feet, and it was the first additional water supply that Met had in 20 years, perhaps. I don't know when I guess 60, we signed the state contract, and here we're in the 80s. So you say more than 20 years was the first new water supply, 50,000 acre feet, and with the expectation of as much as 200,000 or more. I knew, I had in mind certain figures, but you couldn't use big numbers there. You'd frighten away. So we were going to do it in increments and over a period of time. And that's fine. We weren't hurting. So it would work. And we also had deals going with Coachella to reduce their use of water, simply pay them to fallow land, and that all these prerogatives were getting more water that we could rely on that we didn't have. All the growth we've had, and our predecessors at Met had great visions so that our water supply was going to take us way ahead, another 50 or 75 years. But then we saw it was uncertain in the state, became damn uncertain. And so Colorado was the alternative, and the other state agencies, which were irrigation districts, we had to get some of that water. And we would do it first by doing away with waste, and ultimately by buying it. But we also had the argument that only we could buy it, that they weren't free to sell. If they didn't use it, it was ours, and we'd pay them not to use it. It was, again, you could say you're buying water, say we're paying them to leave it there. Interestingly enough, a lot of people didn't appreciate these niceties. They're not in the business, they're not at Metropolitan, they don't know the long-term effects of things. So I don't know if it was the controller's office or the treasurer or someone that issues the bonds, I guess the treasurer. And because IID issues bonds, they felt they had to approve what IID was doing with its water supply. And the way they wrote it up in their memos was that they're selling us water. And if that is not a chagrining happening because of all the care we took with people who understood, outsiders just said they're selling us water. And I'd explain it to them carefully, and they say, well, but from our perspective, it is water that they have, and you're getting it, and you're giving them money. So from our perspective, we have to approve it. Otherwise, they wouldn't have to prove it. And I argued against it, but I knew they'd approve it, so it wasn't a terrible thing. And their actions were not a great precedent. No one, I don't know that anyone's even aware of them in this field, but it was ironic that after the care we took, the other people just thought very differently.
After the initial deal was not approved by the IID board, then there's a period of three or so years where there, at least publicly, didn't seem to be any discussions. And everything is sort of in a hiatus. But ultimately, discussions start up again. And I think, if I recall correctly, sort of the way they were handled is IID appointed one negotiator, one lead negotiator, and Metropolitan had a lead negotiator. And these two gentlemen sort of went off to undisclosed location and tried to hammer out the basic framework of the deal, actually with a lot of detail, as I recall.
Well, just to complete the last point, which was why Abbott and I were involved, I think I've said it, but it was to illustrate the importance of this getting a new supply, this was a breakthrough that people have thought about for decades. And suddenly we're going to get a breakthrough. And having Abbott and myself do it reflected the importance of it. Things were very disappointing after they turned it down, and we waited new elections. And we had some people that, I think, was it Lloyd Allen? Was that his name? Lloyd Allen?
He's a board member, yes.
He was in our favor, and I think he voted the other way. But ultimately, he came around. We left things. Lester Bornt had a great impact on them as a leader. Their manager wasn't permitted and never has been. I mean, the board there are only 5 people, and they really do a lot of the important work, and their manager runs things. He was at all meetings, and he'd speak. He'd give their positions, but then when they got into negotiating, it was one of the directors who had been appointed, and often Lester Bornt. Well, things quieted down after the failure, but then they picked up again. We never let go of it. I mean, I knew these people quite well, and they'd invite me down to a barbecue to address a farm agency, or we hired the former county agricultural agent, and he would set up luncheon meetings in Calexico or some of the other, Westminster or Brawley, and I'd meet different groups and talk to them, and they'd ask me, well, why I did what I did to the Owens Valley. And I'd say, we're not LA. We didn't do that. And no one took Owens Valley. They purchased the rights voluntarily. And I'm not here to defend that. I'm just telling you that those are facts, but that should be divorced from here because we're not doing that. We want to improve your system so that you will get all the water you need, but not more than you need. It won't flow wastefully to the Salton Sea. You will order what you need and get it. It'll be efficiently distributed. But you won't have to order excessive water, and we're paying for it, and it'll be in tens of millions of dollars. And that's, I tell them that, and they were very interested. And ultimately, we started up negotiating again, and we couldn't get anywhere. I was there, and Abbott, and I don't know if you were there at that time. I always had Bob Schemp, who did an engineer who did a lot of the calculations, sometimes others. And we negotiated quite a while, but we weren't getting anywhere. And part of the problem was that the IID board wasn't all together. So Lester, I think it was Lester Bourne who got the board to appoint someone to do negotiating. It was evident that the board as a group negotiating wasn't able to get together. And so I think it was Lester's thought that they hire an outsider to represent them. And we would do the same. Not necessarily hire someone, but just have someone meet with him. And of course, Myron Holbert, having been the chief engineer of the Colorado River Board and having had a career there, was the most eminently qualified. And so he met with Edmonston, Bob Edmonston, and they came up with something that took care of a lot of the concerns. I think it did IID, I think it was at least fair, if not tipped in their favor, because we were taking some risks that situation could change, and we will get the water in particular years. But then I think that would be added on to the contract. If we didn't get it in a particular year, the contract would go another year. I think it was a 30 or 35-year contract. I'm not certain there. So that is the way it happened, as you said. We each had a representative. They came back, and this time I think they had to go first. I'm not certain of that, but I really felt, we can't. Our board won't go first. You're going to have to go first. And they approved it, and we approved it, and that was a breakthrough. And then I got involved in other things, mostly the Central Valley Improvement Act. And Bob Schemp was negotiating, after a while, a second 50,000 acre feet. There was a second contract. Negotiations had started there, but they didn't come through fruition. He did more with Palos Verdes. Halliburton. Yeah. He did more with that, and I was disappointed. When I left, I was disappointed that we never were able to achieve the second contract with IID.
Because you always had it in mind that ultimately you were going to get 200,000 acre feet or more.
Two to four. Just a matter of doing it in increments and illustrating that they're okay. Mm-hmm. That their concerns, and I didn't know where that would stop. According to one report, it would have been 400,000 acre feet, and they could still be farming. It may be that they would choose to farm less and get money. It may be that we would have run out of reasonable conservation projects and buy water. And then it's a matter of negotiating a price you both agree to.
Now, one of the things that happened fairly quickly after IID and Metropolitan boards, respective boards approved the transaction, is Coachella sued and said it was their water. They had the intervening priority between IID and Metropolitan. And so they filed a federal district court case in San Diego. Were you surprised by that? Had Coachella called in advance and said, gee, you guys ought to come and talk to us or we're going to sue you? Or
Well, it goes back a little before that where they said to us, you're dealing with IID, but, we have the right to that water. And we've been negotiating some time. I said, oh, okay, send your delegation and we'll all meet. Well, I think in 5 minutes, IID people walked out. I mean, they have such a long-standing animosity, hostility. I don't know that it lasts every day, but they generally they don't have great love for one another, and so I just illustrated. I hope that wouldn't happen, but I illustrated why we could only deal with one at a time. That you say we ought to be there. Well, people from two representatives just left the room, wouldn't sit in the same place after 5 minutes. See, because they had so many other quarrels over the years and currently that you couldn't isolate this problem in their personalities, in their presence. So we went back to meeting with IID. So I know that Coachella was there. I mean, they were going to urge put it that way, they were going to demand their pound of flesh. And but I was surprised that they did it the way they did it. Filing of a lawsuit was unnecessary, but I guess to them it showed that how important it was, how strongly they felt. I mean, from their vantage, they felt that's the way to go. I thought we all knew each other so well for so long that we should have. I expected to negotiate with them. Well, we did. I mean, they filed the lawsuit and then we negotiated. Maybe they felt that was a club over our head. I don't think it was. I never felt that way. I respected their legal position, and so in the negotiations, I was affected by that. I thought the lawsuit was superfluous because we would never have ignored them because then we would be subject to a lawsuit. I think they were premature, but that's the way they saw it, their interest. And so further negotiations took place and they made some modifications in their favor, and under certain circumstances they got water, and I think Holbert negotiated with them too. And again, Met has a history of being more considerate. Not everyone will agree with that, but I think we recognize the merits of other arguments, and we do make allowances for them. We've done that in lots of situations, water and otherwise. And so I think we made them whole, frankly. So they were satisfied. They signed off a revised agreement. I think it was by 88 by then.
88, 89
Yeah.
time frame. I think another event that's going on around the same time period is Metropolitan's pursuing federal legislation to line the All-American Canal.
Yes, another area of conserving water is, part of the Ulmer Canal, I think, was already lined. I think Coachella portion, or maybe not all of it. So we pushed for that, and we were that was resisted by IID. And I remember hearing before George Miller's committee, and we said, with the drought on and looking to the future growth. We want to conserve water. This is water that's being wasted. And we pay for conserving it. And with a position like that, it put IID in a hard place to say, well, we don't want that done. And they did, but they did. They said, we don't want it done. We're against that. That's water that should be ours. And I think someone on the committee said, well, are you going to do this? Are you, no? Why do you want the water? You're getting everything you want. Well, someday it might be worth it to sell that water. Then we would do the lining and have water for sale. And I think the committee head just shook his head and says, here, we need water now, and you just want to put this off, so someday you may do it, and you may sell it, and you may make a profit, while major cities in California are short of water. That's the way that's what you told me. And you know, there was no one on the committee there that just paid any attention to that, their position. But I was surprised that Dennis Underwood was the head of reclamation. Is that right? Reclamation. I think, yeah. He came down there and he gave a statement. He was against the legislation. I don't think he went into it in detail. He said, you know, something vague along the lines that we don't think this legislation is the way to handle it. I mean, you know, he did something that tried to be innocuous, but the chairman had no regard for that. I mean, he just, I think, said, yeah, all I've heard from reclamation is on most things are negative and not helpful at all. I mean, he didn't give that any weight to my mind. But before that legislation could get anywhere, we had to agree that IID had the option of doing it themselves or doing or contributing with others toward it and then getting a portion of what's saved. So even though we did fare well on that committee meeting, and I think it was a subcommittee, the fight was by no means over. The full committee, the Congress, and the Senate, and I must say I've always been impressed with the farmers, whether they be in Central Valley or Imperial Valley or anywhere else, having good relations with Congress, having people on the right committees, and being able to organize opposition from different states, different farming states. Their legislators would all get together. So I knew from other experiences that just getting out of that committee wasn't enough, and we did have to compromise. And I don't know what whatever happened to that.
Well,
If they added the Indian group in San Diego, that became so terribly complicated. But I think they may have done that, and you know, we got the crux of what we wanted, but I don't think did it ever happen?
Well, I think just very recently some funding contracts were signed because the state appropriated some money to assist the agencies in actually, you know, completing those projects. But
well, will several agencies, IID and Med and others, be involved?
I think the way it works, if I recall correctly, is part of the overall quantification settlement agreement that, you know, involves the IID San Diego transfer and all of these things.
Oh, right.
The allocation of the water from the canal lining projects is all folded
part
in
of that.
there. And if I recall correctly, Metropolitan gets majority of the water, although 16,000 acre feet goes to the San Luis Rey Indian.
From Met's portion?
From the
Or from
lighting
the,
project.
yeah, lighting project, okay. Well, that was happening or happened just as I left.
Oh, is that right? Oh,
Yeah.
yeah. Oh.
Yeah, I know there was this grand thing that came along, but it wasn't yet there when I left in '93, early '93. Karen, do you want to pursue this or any longer, or do you want to go to the litigation in Colorado River?
Yeah, I think I thought we'd go back to the case a little bit,
Okay.
and talk about, I think you were still in the AG's office for a while. And
I
after,
left in 1976.
okay, so the decision comes down in 63, Arizona versus California, followed by the court's decree in 1964. Then there's a period of time in which the parties are tasked by the court with trying to figure out the present perfected rights.
Mm-hmm.
And while I think the court initially, if I recall correctly, had anticipated that the parties would return within a year, perhaps two, with the list of present perfected rights, it took far beyond that period of time. And I was wondering, when you were at the AG's office, was that it looking at California's present perfected rights, that was something that was probably supervised by you because it would have been in your section. The Colorado River Board would have been involved in those discussions, but did you have any involvement?
No, I don't recall any involvement. At that time, it might well be that Jane Goichman was sitting with the board and I wasn't. And I may have discussed things with her, but I don't recall it. I was involved in a lot of other things in the public resources area, and I no longer attended those meetings on a regular basis, but just occasionally. I don't have a recollection of being involved in this. That's to the best of my recollection. I know what happened when I was at Met, and I went over in '76, and this came in, and I was the assistant general counsel, and Bob Will and others worked out. And I don't believe I was in it then. I think he worked on it for Met, and a lot of parties all agreed to certain of the present perfected rights and went back to court, and there was a hearing, and it was all by agreement, so there was no not a real trial or anything over that. It was more administrative. Maybe they asked some questions and all. Bob handled it, and it was fine. And then it was after. When did they file their suit?
79.
Yeah.
Well, 78, 79.
Yeah, and I was at Met's from June or July of '76. So when their suit came in, I wanted to handle that because I'd seen too many cases that were going to go to the Supreme Court when I was in the Attorney General's office, and I didn't get to take them. So I said, I'll do this one. And Bob wanted me to. Bob was there through '80. And I went to the Attorney General's office to tell them I would do this. And they, because I wanted to clear up any question that I had a conflict, that I had worked for the Colorado River Board, and there was a conflict. And I think Attorney General Younger was running for governor, and they took a position that there could be a conflict that I couldn't imagine, because I hadn't worked on Colorado River Matters, and whatever we did, we were on the same side. The state and that worked together, but they had turned it down, and I was very disappointed. But then the election happened, and there was a new attorney general, and so I went back and explained it all again, and this attorney general agreed that he didn't see that there was a conflict, and indeed by then it was very clear that state and Met were going to take the same position, and that nothing I worked on in the past related to this, the issues here. Anyway, I was given permission, and I worked the case, and Warren Abbott handled the running of the office, and I was out at trial. And we early we knew, Arizona was a party. Lots of people were named parties who didn't appear or appeared occasionally. San Diego Water Authority would send an attorney occasionally, not, and sometimes another agency, sometimes, I don't know if Coachella, yeah, I guess, no, Coachella I don't think came, but Redwine and Cheryl were representing
They represent Coachella.
Coachella. Well, then okay. I was thinking of Roy Mann, who represents Palo Verde. Yeah, he never came, but Redwine and Cheryl came for Coachella, and they came not all the time, but late in the trial they were there all the time by Justin McCarthy. And Doug Noble worked for the state. He was a senior deputy who represented the state, and Ralph Hunsaker represented Arizona. And so we formed a group, and it was Arizona and Metropolitan and the state that would be the main parties having the laboring order. We'd outline our case and do this and that, and occasionally we had help from others. And we organized it and sifted through the issues, and you recall probably better than I that they insisted that some of their land they didn't make. The case Arizona, California decided that you could measure the water right by practicable acreage, so that was the standard. They said, on those reservations, I remember 4, there may have been 5, but I remember just Chemehuevi and Cape Chan and Mojave in Colorado. And if there was another one, I don't recall it. And Arizona had some interests, some of them not as much as California. So we looked at the issues, and they were saying we want more water because we didn't ask for enough for the lands that we thought were irrigable. We also didn't ask for any on some lands within the reservation. And in addition, the boundaries were incorrect. And there's additional irrigable acreage. Now that's to the best of my memory, and the Indian attorney, the Indian briefs were very critical of the United States, the way it was handled in the original case. Critical is a mild word. They were furious. They used terrible wording in their papers. The United States had defrauded them, were incompetent, and yet here they are petitioning the court to have further proceedings in this case, and they were together. Well, I concluded that the United States wasn't fraudulent, and if you want to be critical, you could say they weren't as imaginative as all of us were 20 plus years later. you're plowing new ground and figuring out how much water they have a right to. And with any new concept, you tend to be a little conservative. And then I can't rule out that they, they're not unaware of the impact of what they do on others. And their position wasn't as aggressive as today's attorneys would be. But I have no reason to believe they weren't doing their best, that they didn't think it through as well as you would today. They'd probably agree, but they were doing their best. And in any case, I felt that immediately you can't retry a case 20 years later. You can't say I didn't urge the best science to get the most water on the lands that I thought irrigable. You can't say that there's other lands that are irrigable that I failed to put forward, and they call them unadjudicated lands, which really is a way of saying, well, we severed our cause of action. Well, you can't do that. You can't go being in a train wreck and having a broken leg and having gone to trial and be compensated, and then 20 years later say, you know, I never mentioned my other leg. You simply are regarded as making your full claim, and that's a pretty well-established law and judicial rule, and that's the way it has to be. So they can't sever their claim. They can't say there's unadjudicated lands. They made the claim for the reservation, and what they got was the reservation. They showed what they had to get a water supply, and you can't just cutely say there's unadjudicated lands. They were adjudicated. They were adjudicated by you, not putting forward that they had any water right in the computations.
Were the state agencies surprised when the U.S. moved to reopen Arizona versus California?
I believe so. It seemed to be a shock to the legal department. I don't know that anyone phoned Bob and said, you know, you'll be getting this. It's not impossible that they phoned him and say, you'll be served tomorrow. But there wasn't a lengthy discussion, to my knowledge, that that there's going to be litigation, that the case is going to be reopened. I don't recall that.
So it was a pretty steep learning curve, I suppose, for everyone then to
It was.
familiarize yourself with the issues.
Yes, it was, but you know, we had met a Colorado River Library. We had loads of documents and briefs and volumes and evidence from the first case. And we had Jerry Mize, who worked as a special counsel for Metropolitan, who had been on Mike Ely's team in the first case, and really is hugely knowledgeable about this. I had read the cases. I had set about getting the briefs and yes, it was a learning curve, but there was certain things on the surface that were so patently wrong that you didn't have to know everything. I mean, you had time with the learning curve, and then the boundary changes. You might have taken a position that they can't even, 20 years later, there's res judicata on whatever the reservation has. You can't retry it, and you can't nicely cut it up and say, well, we didn't try this unadjudicated part. It is tried. It's part of the reservation. The boundaries represented a more difficult thing because they said the boundaries were in error. We've corrected the errors, and there's additional lands that were never adjudicated, that were not before the court. but you could argue that they were before the court, that but, but in fact, the boundaries had been raised in the original case. And the master had made findings on the boundaries. And so that part could have been done. But as best I understood it from Jerry and others, our position at the trial changed, before the Supreme Court changed. We, instead of pushing that the boundaries had been established and his grant of water rights, however, we were attacking it on the merits of irrigable acreage, but the boundaries were fixed by the master. We said before the Supreme Court that we're not asking them to make a decision on the boundaries. That we're satisfied with the water end of it, and the boundaries can be tried in the normal course of land ownership, and we could come back when the boundaries are finally adjudicated. And I think I don't have a good reason for why we would back away from something that we tried. I mean, we tried those issues, and as far as I could understand, we're satisfied with it, whether we won some or lost some. We were satisfied, they were adjudicated, and we backed away. So we were stuck. I could say that I'd like to have said the reservation is done. It's done 20 years ago. But because we backed away and the Supreme Court says we're not making findings as to the boundaries, you can come back after final adjudication if you feel more water should be allocated. Well, so there was no way of avoiding the boundaries. And I think everyone's natural idea would be, okay, we're going to argue whether these new boundaries are correct. And I was very surprised when the United States took the position that that's not an issue that we can try. We don't have standing to try the new boundary lands, the new boundaries. That's a plenary power of the Department of the Interior, and that only a landowner adjacent to the reservation whose land has been diminished could challenge the boundary. We could not. And I said, you're diminishing, or the purpose of this and potential is to diminishing our water right. It's no different than owning land. It's a species of real property. And even whether you call it that or not, but it is a species of real property. But the point is, you're running all over us. We're not getting a day in court over that. And I know that's an appealing thing because that's what the law is all about. So I made a motion before the master that I had done some research about this master. He was a brilliant man, a courageous man. He was quite on in years. He was in his 80s. He was emeritus in circuit court, Fifth Circuit, I believe, Atlanta, and sometimes in New Orleans. He had been involved in the civil rights cases. He was one of 3 judges who books have been written about, because the Supreme Court would come down with Supreme Court edicts, whether it's Brown versus the board or other cases. But then no one runs up to them. They run in the trial district courts, trial. And it's the circuit courts that are in the trenches, really, having to reverse orders, against public officials to carry out the Supreme Court's intent. It was that a circuit court those members were the heroes because it was busy, quick. They had to act quickly because the lower court reflects too often, I don't want to say always, but certainly too often, the feeling of the community. That's why you have the more dispassionate judges in circuit court. So he was a great figure to me. What I overlooked was I mean, a lot of fame came from that, but he had been a lawyer, he'd been a politician, backed Eisenhower against the party, against Taft, I believe. And he was part of the new Republican group and way back, and he was quite a man. And
So you thought
I
this
thought,
argument
well,
would have great appeal to.
oh yes, I said,
Yes.
well, sure. Just on its face, there's the lack of fairness. And but what happened, and I didn't see it quickly. I thought he made a mistake. I'll explain that. But what came to me during over 2 years of hearings here and there, where he rode the circuit, we rode with him, whether it's Atlanta or Denver, or once in LA, and I don't know, maybe Phoenix. But he saw the Indians as the underdogs, just as he saw the African Americans as underdogs. I mean, that had gotten to him in such a way that I truly feel he was no longer able to be a fair judge. But we're well into the case by then. I was still feeling, well, he made a mistake. He ruled, no, they have the Department of Interior has plenary jurisdiction. There are cases that say that, well, for different purposes. I mean, there's nothing like this that they could cite. So we were only allowed to challenge the water allocation on new lands that resulted from changed boundaries.
Did you appeal the master's
I yes,
to the court?
yes. I said, oh, he's made a mistake. And in retrospect, I wouldn't do that again. I appealed. I petitioned the Supreme Court. I said, here it is. It's all unfair. Well, they're very busy, and they said we'll address that when we get the master's report. And I had put in, we're going to have to go through a year or more of evidence on what could grow on this land, even though the boundary may not be there. I mean, it's going to be costly and time consuming. Didn't matter. Now, in retrospect, I feel he was so biased that if he took that issue up, he'd have ruled for them. And so, in that sense, strategically, it was a mistake to challenge him. We should have just lived with his order. Well, in fact, that's what happened because the Supreme Court didn't want to take it up. When the case finally got there, they had already proven water allocation for unadjudicated lands and for new lands. And we went through trial, and it was Doug Noble of the state that handled the factual issues of what could grow, what was profitable, what could you do profitable farming on any of the acreage that they're now claiming was not allocated a water supply. And we felt you could not. We had our experts and they had theirs, and he allocated new water for them.
Yeah, I perceive another interesting sort of preliminary procedural issue was the tribes actually got 2 bites at the apple, so to speak, because the United States represented them, and they also had an independent tribal council of their own choosing, so they could. And as I recall, I think the tribal council made larger claims for some of the practically irrigable acreage than even the United States claimed on their behalf. But it must have been kind of interesting procedurally that it's two cases in a way.
You know, that's so, and it's likely that the Indians were more aggressive in claiming water than the United States was even then. And I think the United States was going a long way, but that they didn't go as long as the Indian Council. But by having differences there, they nailed down that they're entitled to separate representation, that each could speak. See, you can have loads of parties in a case, and often on the same side, the judge will say, well, you select who's going to speak. I'm going to listen to 10 people. But he didn't do that here because they had this distinction. So the Indian Council would cross-examine, the United States Attorney would cross-examine. And most of the time, 98% of the time, they were together on things, but occasionally they weren't, but they all were permitted to speak. And certainly the Indian Council in the trial was, I think it was Tom McElhone, and he, an Indian, and the judge was very complimentary, encouraging of him, and rightly so. And it just, as time went on, it just became more and more clear that the judge liked these people, apart from their merits. He liked them. And, well, it was just, we felt under siege. We felt we didn't have a fair judge. And by this time, we're just making a record, the best record we could for objecting to what we expected.
Yeah, but who represented the United States?
Well, it was a fellow named McElroy, a younger fellow, and then Miles Flint, a more senior career person in the United States Attorney's Office, I guess, Attorney General. What do you call it? I guess it's the United States Department of Justice, and they were deputies in that department, or associates, or assistants. And they were experienced attorneys, and they did a good job. But you could see that they, you could see the judge favored them in so many ways. We jointly put forward all the issues. He asked us to do that, and then we had some they wouldn't agree, and they had some we wouldn't agree. And he just looked at ours, and he would just deny it. And at one point, McElroy had to say, "Oh, well, we agree that that's an issue." He said, "Okay." I mean, it was just so patent that whenever they needed a continuance, they got it. And when we wanted one, it was often denied. They're little things, and we almost decided to bring that up, but I thought we were so strong in the merits that would take away from the merits. So we went through a lengthy trial and on lots of things, and then brought back to the Supreme Court the same issues that we had raised in our petition to stop Judge Tuttle way back. And we really won on those issues. They said, gee whiz, 20 years goes by. Can you imagine? Does it mean all Indian litigation can be raised again if you have new ideas, better ideas, even though it's 20 years old? Should we expect that kind of thing if we do that? And so he said, your res judicata covered the reservation. Now, with regard to boundaries, they haven't been finally adjudicated. And so he wouldn't give them anything there. Now, we anticipated a problem here. We wanted the master to do the boundaries. We wanted Supreme Court to send it back, to have it done here. And to do that, I asked Warren to file a suit in the district court in San Diego regarding boundaries. And they took the position that there's no jurisdiction. And I don't know that we appeal that. I mean, that the whole purpose there was to be able to argue to the Supreme Court that if we can't, they say we can't do it here, and they're saying we can't do it there. So we really boxed them in. And those things work well. The attorney for the Indians was not the trial attorney. I think he was there sometimes. Well, maybe he was there all the time. There are more than one attorney for the Indians, but this one argued, and they gave him, I'd say, a tough time. I mean, they asked a lot of questions, and he would turn his yellow pad to find where he is, and he finally sat down before his time was up.
I think that was Lawrence Ashenbrenner.
Was it? It sounds right. And I was thinking, God, I could use that time. Can I ask them for his time? I better not push it, because they were very helpful to me. Their questions were very good. Even those that were favored the Indians would ask questions that simply let me make my argument. And so I thought it went well. Now, I was surprised that it was only 5-3, the decision. And Justice, he was former Attorney General, that's why he recused himself.
Thurgood Marshall.
Thurgood Marshall. Yeah, he recused himself. Now, if he hadn't, I'm sure it would have been 5-4. And I thought we had a strong case. So it was 5-3, which tells you how sympathetic the widow and orphan, and whether it's the original Arizona versus California or the Indians, there's great sympathy there. So you had to jeopardize some very important legal matters to win. You couldn't just win your big Met and they were Indian. You had to say, can you come back? Can we ask you to review things after 20 years that have been adjudicated? I mean, is that going to be? Can you have new water allocations on boundaries that they arbitrarily fix that we think are mistaken, and we don't have an opportunity to show that they're mistaken? We can't do it in the district court, they say, and now they're saying you can't do it here. So, with that kind of thing, fairness and important judicial things like res judicata, you can offset a natural sympathy, which I think we all have, certainly I do, for the Indians, the plight of the Indians. But that was the way it developed, and I think Ralph did a good job for the state. I mean, I think he lost some minor points, but he didn't, he thought he'd throw him out there, but he wasn't surprised that he didn't win those minor points. And so I was very pleased, and I left, and I know that perhaps you and others I know you worked on boundaries.
And it's still going on today.
It's still going on.
Yeah. So I'm kind of gathering that you all were not at all surprised by Master Tuttle's decision.
No.
That you clearly anticipated that you would lose, and water rights would be awarded to the reservations. And
that happened. We may have been surprised on particulars that he allowed this, and that on some things he didn't allow, but basically it was heavily in their favor, and we weren't surprised. There's not much we could do if we got to allocating water based on irrigable acres, because those are findings of fact, but we never got there, before the Supreme Court. But interestingly enough, and this is an aside, this case came down Master Tuttle's opinion came down. And papers of Met loses water and all that. And it was right, just a few months, maybe 3 months before the election on the Peripheral Canal. And I went to lunch with some people from Met and outside. Uh, I guess he was involved in running the campaign, this outside firm representative. And I said, yeah, we lost this. We're going to the Supreme Court now. He says, why are you looking sad? His view was that this helps him push for the Peripheral Canal. We need that water. See, I mean, people have what's on their mind comes first. So I felt at the time, though, and I told the assistant manager Kennedy that I think we're going to win. I mean, I think when the Supreme Court sees this, they will weigh what's happening here and that we will win. And it came out that way. And he came in when he read it. He said, you said that you'd win and you won. God, I haven't run into many lawyers like that around here. But the thing was that so basically flawed with that master.
Tell me a little bit about, I think Louis Claiborne was the solicitor who argued on behalf of the United States at
Yeah.
the Supreme Court.
Yeah.
He was kind of a colorful character.
Yes, he is an Englishman, and he used to practice in England. He would go back each year for a period of time and be. Was told me by someone. He was very interesting, eccentric. His manner was very English, and he was experienced. He had argued a lot up there as an assistant solicitor, and they gave him a hard time too, because they forced him to say something rather shocking. When they were locked in, I mean, they said, look, they got to try the boundary. That's fair. And you say you can't try it in the trial court. You've said that. He said, Your Honor, I disown whatever went on in that case in San Diego. Well, how do you do that? I mean, they nodded, but that's not what does it. I mean, he could disown it personally, but he was in a trap. He was saying it's not right for you to have those boundaries in this case. And since he was stuck with what they did there, and I knew they would do that. I mean, you just knew their arrogance isn't the right word, but maybe overconfidence. When you're in a field of public law, you get somewhat narrow. You get very firm or atrophied sometimes, and you say no one could challenge boundaries. So you say it wherever it's raised, and they don't look to see. Well, there's no room. There's no one going to be able to challenge the boundaries, and the Supreme Court is going to say, well, they have a right. If their water right is going to be affected, they have to be able to challenge the boundary. And all the assistant solicitor could say is, I disown what they did there. Well, you're all one government. You could disown it. That doesn't change what's going on over there. But Louis Claiborne was a colorful figure. I think he died a few years ago.
I think, Carl, we were talking a little bit about Louis Claiborne and some of your impressions of him, who was the associate solicitor that argued in the Supreme Court the boundary case.
Yes, and I say he was well prepared, and the difficulty that I mentioned that he was in was not of his own making, but his attempted way out was a shock to everybody, because people in the audience were from the Department of Justice, and I could hear, because you just can't shake off what your department's doing. But, he argues well, I think we had the merits. I'm still a little nervous that it was only 5-3, but we did have the merits.
I think some people probably are not aware of the way that the Department of Justice or Justice Department and Interior, all of that, how their legal representation works, so that the solicitor argues cases before the Supreme Court, but had nothing really to do with the actual trial of the matter. So Mr. Claiborne really would not have been in a position to influence very much that happened at the trial level. Is that right?
That's true. In fact, he probably wouldn't even be aware of what went on until it got to the Supreme Court by way of petition. I don't know at what point he reads it, whether he waits till they act on the petition. I would think he would wait because there's a lot of petitions that are rejected. So yes, he couldn't have influenced them. It just seemed that the others were surprised when he did that. And indeed, it still strikes me as peculiar. I attended a meeting with I'm sorry, I can't remember the official's name, but it could have been in the Department of Interior in Washington. And there were a lot of young people there in the department and in the Justice Department. And they all came up and shook my hand. They said they were at the case, and this was before the decision came down, and it just the case had a lot of following, even though it's a very small part of the big picture of Colorado River. Seemed of great interest to a lot of people, certainly to the participants.
Can you tell us a little bit? I mean, it's not often, as lawyers, we have the opportunity to argue a case to the United States Supreme Court. As you point out, very few petitions are accepted annually by the court. So tell us a little bit about how you went about preparing to argue before the court.
Well, I'll certainly be glad to do that. I can say that I've always had, after I became a lawyer, the idea that it would be just fantastic if I got to argue for the Supreme Court. I don't know that I'm an especially good arguer. I always felt a little uneasy in the state appellate courts, and yet I had a lot of appellate experience for the state appellate courts and the state Supreme Court, because that's what you did in the Attorney General's office, especially in criminal matters. And I always was a little nervous before you go in, but then once you start speaking, it's all gone. And that reflects whether you're prepared. If you're prepared, it doesn't matter that you know in advance, then the U.S. Supreme Court isn't going to let you get through a whole sentence if it's a long one. And so you prepare by having an argument set out in a general sequence, but are ready for questions that may come in the middle or late in your sequence. And you have to answer them and still make sure you get your arguments in, or decide at the moment which arguments to drop. Maybe it took too long to answer that question. And so you prioritize your arguments, and you may drop some. After all, they're all in writing in your brief. And you take the cue from their questions as to what interests they have. So certainly you want to dwell on their question, which brings up part of your argument. So I was prepared, I thought, as well as I could be in terms of the research. I had written and researched my work. I had Richard and then yourself check cases for me and maybe give me a brief of particular cases. But essentially, I had written the petition to the Supreme Court to stop the master going forward. I used a lot of that at the end, and I felt very comfortable knowing the cases that were relevant and our arguments. Of course, it doesn't matter. I've always looked forward to this, but you're still going to be nervous. So an example of that is I memorized the names of all 9 justices so that when I answered, I could use their name. Well, I never used their name. At the very last moment, I wasn't going to take, it would be worse to make a mistake than just to answer, Your Honor. And yet I had bothered because I knew, well, that gives you a little more. They'd like that. And you had to make that decision right at the time. Well, I was a little nervous, not going to take a chance, go on. And then, depending on their questions, I pick up my argument, try to keep it the sequence going. When I write anything, any kind of argument, even opinions in the AG's office, you always wrote, and everything had to lead you to the point you want. And you had to discard things that were very clever or excellent. But if you look it over, it really is an aside, or it detracts from where you're going, and you had to cut it out. So you're aware of that, all that when you wrote it, and you're aware of that when you're speaking. The questions. So I say to start with, this was something I had seen slip by me while I was in the Attorney General's office a half a dozen times. And now I really was so pleased that I had this opportunity. And so I prepared just again and again. I had no hesitancy in reviewing things the third time, the fourth time, thinking of a case, wanting to check it again, thinking through how it applies, getting your help, getting Richard's help. And then we went to Washington. You and the others all met in the room and all questioned me as if you were the court. And I had to answer those questions. That was very helpful because I had to think quickly and keep my organization of thought going. And I remember once saying, when I think McCarthy or someone said, I said, well, if the court says that, it's wrong. And he says, nope, the court is never wrong unless you have someone to appeal their decision. Their decision is it. Per se, they can't be wrong. Whatever they say is so. Of course, that's correct. And so I just worked with everything. And as a kind of a colorful thing, is my wife initially, when I told her I'd go back there, and she said, well, I'll come back with you. And she likes Washington. We go to this museum and that. I says, well, I'm just going to work on this case. I'm going 3 days early. I'm going to work on this case. And afterward, I'll go somewhere. She said, well, I'm not going to go back and just sit there. So a month later, she says, well, I was with my friends and I told them you're going there. And they all said, well, you ought to go. Are you going, aren't you? So she says, I guess I'm going to go. So I said, okay, but I'm still working on this case. And so she'll come one day ahead. And I got reservations for a hotel across the street so that she didn't stay with me. Now that's maybe going above and beyond, but I was going to concentrate and work hard on that case. And so she brought my son, who I thought I would influence and didn't, or I didn't influence him positively. He's not a lawyer. And so she was across the street. And then that morning, I picked her up and we all walked to the Supreme Court. And I was pleased with the argument. It was exciting, win or lose, just being there and hearing them. I mean, the questions come thick and fast. You're hard pressed to get to all your argument in. And so you're making decisions right along as to what you're going to delete to stay within the strict time limits.
And here the argument was divided. You had a certain number of minutes, and I think Ralph Hunziker had a certain number of minutes and so forth. So
we're given a half hour each, and the Indian Council was half hour and the U.S. Attorney half hour. So that was longer than most cases, but since there were 4 parties and they couldn't, well, they had a terrible time I think there were letters, I got copies of letters to the Supreme Court saying other Indian council wanted to argue. And they had a heck of a time choosing Ashenbrenner because other tribes wanted to send their fellow, and the Supreme Court was going to have one person.
Did you, when you were up there arguing, did you feel like you had a good sense of how much time had elapsed, and so you knew how much time you had left to make, your following points, or?
Uh, Generally, yes. I could feel how long I took to answer a question. And then, of course, there's the white light that goes on in 20, no, the white light is on, I guess, at the beginning. And when there's 5 minutes to go, I'm sorry, 25 minutes, a white light will go on to warn you have 5 minutes. And you can use that 5 minutes to continue your argument, or you could save some of it for rebuttal. And then a red light goes on when the half hour is up, and you stop in mid-sentence. It's over. Well, I did want to save 2 or 3 minutes. And suddenly there's a red light on. And I said, so I stopped and I said, I was supposed to save something for rebuttal. And they shook their heads and laughed. They just chuckled, it's over. And I was glad because I got out what I wanted to get out. And then Hunsinger did his job well, but the other side was hard pressed by the court. You could tell that they were leaning for me. I thought it would be better than. I still haven't figured out why 3 would go the other way in light of the arguments, and the nature of the issues, other than to say that in fact the U.S. 20 years ago hadn't done the best job looked at today, so that the Indians probably could have gotten more water, but it was 20 years ago. And, I mean, I maybe that entered into them. And there's no question that if the same rules and approach were used that far back as it would be today, they'd get more. And of course, if they had that same approach would have allowed them to put forward more land on the reservation than they did. They were conservative. It was a new thing. Sometimes when you push a new thing and you push it all the way, you lose it. So they probably were thinking, this is new, it's a good idea. Let's not take a chance that it'll do too much. I don't know. Of course, there were different people, but I got across everything, and I think we did. I was very pleased. I was pleased with the outcome, but in truth, as a lawyer, I was pleased with the experience.
Oh, what a great experience. Like I said, not that many of us really have that opportunity.
And it's chance. It's chance selects you, but then it's up to you.
Well, I'd like kind of your impression of some of the folks that you've had the chance to work with over the years. We talked a little bit about Mike Ely, for example, who, of course, we all think of in terms of the Boulder Canyon Project contracts, as well as the Arizona, California litigation. And then I think he went on for a while and represented ID on the 160-acre limitation case that made its way to the court. And
I think I think Melviny may have represented them on the 160-acre limitation. That doesn't mean Mike wasn't also representing them, but I remember the argument, at least at the trial level, was Pierce Works. But, but I say Mike was a giant. He was a small man with a large head, and he was a giant in his field, resources, municipal ownership of power, things like that. And he was known internationally. I remember he was on his way to Indonesia once. One of his friends I saw once said, I ran into Mike. And I said, what are you doing here? He says, well, I'm flying to Indonesia. Some maybe draft legislation for them. But he was extremely well known, as tough as they come, well prepared, clever, and he didn't have many inhibitions either. I remember once he represented Edison and the city of LA on hydropower from Hoover, and Met was on the other side of that, and I was arguing with him as I think general manager. It was an administrative hearing, and he kept saying he wants to hear from Harvigo. Harvigo is their advisor. He's the one that tells them what to do. Let's get him up here. Well, Harvigo was sitting next to me, and while he argued, we chatted. But he had, that's really not done. But you see, it is done. He had few inhibitions, but he was a very successful man, a very extremely bright man, and lived a long time, and has the respect of a lot of very capable people.
Jerry Mize,
Jerry Mize worked with us. He was not of record in that case, to my recollection, but we did confer with him, and he did submit some written materials for us on the briefing. And since I decided to try the case, with the state and Arizona, we did make use of Jerry, other than to check things and get reactions. And I say he did offer some suggestions and some material. Jerry is, in my opinion, the most knowledgeable person that I can think of on Colorado River matters. And he's extraordinarily aware of the history and the development of the different issues. And it's been just quite marvelous that Met has him as an advisor, and through the years, sadly, under an earlier manager, they just didn't take his advice. But he had done an amazing amount of work. I read a good deal of it, and it was excellent work, but it required at least if not aggressive, certainly a positive initiative. Met had to take the initiative to test a lot of issues and get our points across, and we had a manager that just didn't allow it. So it must have been very frustrating to him, but perhaps with the current manager, things will be different. But there's just no one I know that has greater legal knowledge. Holbert is outstanding in his knowledge of the facts and operations and history and legislature. And I just another extraordinary source. But Jerry is probably the number one attorney that I consider anything involving Colorado River and Met's.
tell us a little bit about Myron. I assume that you met him through your dealings at the Colorado River Board.
Exactly. He was, I was the attorney, and that made me in great part his attorney, since he's the one I would deal with. Though I was the board's attorney, but you deal with the executive officer or chief engineer in that case. And Myron could not help but impress anyone with his knowledge. And he is so well organized and prepared that it's hard to, gets hard to argue with Myron. He's simply that, he has that background and is that well organized. And I think he's just, well, I don't think there's any manager like Myron. And I hired him away when I became manager, and probably a year later, when there was the opportunity, I hired Myron to be assistant manager at Metropolitan, and he's just as anticipated, a very great help. I say I knew him from the board, and we had some social relationship. I know his wife quite well. She was very close to my wife later on in years. But at the beginning, I didn't know him that well personally or socially, I should say, but professionally, he just stood out, just stood out very clearly. It'd be wonderful if the state or any public agency can attract first-rate people like that and keep them.
Tell us a little bit about Doug Noble. I assume that you asked him to work with the Colorado River Board, and he had that assignment over many, many years then.
I don't know that, I'm not sure that he was assigned to the Colorado River Board while I was there. It may be, but I'm not sure. He worked in the public resources section. He worked in a different section, and he came to me one day and asked if he could transfer into my section if I had a vacancy, and I did, and the transfer came to pass. And he's an excellent attorney. He's a Stanford law grad, and he just did very fine work. And then after I left, he became in charge of the LA office, and I had a lot to do with him, Colorado River Matters, when I was at Metropolitan. And of course, I know him socially very well over the years. And he took a big part of the case, the Indian water rights case, by just saying, well, I'm going to handle the legal issues for California, and Hunsaker will handle all issues for Arizona. And Doug, would you handle the factual issues? And that meant a very difficult thing. I mean, I learned it and I oversaw it, but he did the basic research and writing, all the writing, the appellate matters on the petition on that part, and that's to just review their experts' decision that you could pipe water in and handle all the costs of irrigation and planting and get a good enough price at the market for this particular crop so that you could say this is practicably irrigable acreage, practically in the sense that you would farm it with a profit. And so he had to review what if they grow cotton or jojoba beans or grapes in this area, in that area. What are the engineering costs? What are the water costs? What are all the related farm costs? What are marketing costs? What will the market be based on in the future, based on what the past was? It was a very difficult thing to do. He did it very well, and it's a wonderful thing to be able to divide up a case and have confidence in someone that you can just review their work and not have to do more than you can do, frankly. So we had a good, strong team.
Why was the case was tried in several different cities over a long period of time? Why wasn't it just one location and, we'll just go 6 months straight or whatever
Well,
time period?
because Judge Tuttle was emeritus, and he liked to travel. He told us so. He and his wife liked to travel, and so he volunteered to fill in across the country for judges when they took their vacations or were otherwise indisposed. And so he, they'd arrange it, and he'd have 2 weeks in Colorado and a week in Arizona and 3 weeks in Atlanta. And it would move around like that. And the case ended, I think, a half day in Pasadena because he was going to be here. And that's how it happened simply.
So logistically, you just kept having to pack up all of your boxes and
Yes,
move all around the country.
that's true, but there were substantial intervals. We'd be 2 or 3 weeks in trial, and then maybe it was 3 months or more later that we know we'd be in Denver. And yes, a logistic problem, but no one seemed to have trouble with it. It allowed you to think through what went on and work toward the next points. Of course, we had experts with us at all times, and as did the United States. No one seemed troubled by that. If they were, it wasn't apparent about
And how was the master paid?
I think we all contributed to. I haven't thought about this for some time, but it seemed to me there was some kind of bank account set up, and we had to pay into that account, and that his clerk would send us bills, various expenses, and we'd have to pay that. And I remember once the clerk told the judge we hadn't paid something. The judge was very, very annoyed at that. And I think it was, we hadn't gotten the bill. I mean, it was missent to the Attorney General's office or something like that, and it was Met that was handling it. But somehow it was misaddressed, and everything calmed down. But it was something you had to work out with the master, and I guess that's the custom. You work out payment with the master.
Was he paid by the hour, or did you pay him for days?
I'm going, it would be a guess that it was by the hour. But I really don't remember that. I remember only that there was such a bank account that was utilized, and his clerk used to call us and go over things.
Bob Will.
Bob Will was the general counsel until 1980, when he left to go to Washington and open up a lobbying firm, legal lobbying, but I think was essentially a lobbying firm. And for quite a while, he and Mize were the firm, plus some help, but it was Will and Mize. So I guess it was just a normal legal firm, but Bob's interest in the law was in lobbying, was in legislation. Very attracted to that, and he's very good at it. He had done it before for Met, and now he just started his own firm. So Bob hired me because he met me from at the Colorado River Board. He knew me from my work there. I didn't know him well. I mean, I knew him just because I used to see him, but I didn't get to know him until he asked me to come over to Met. And we had a very, very good working relationship. He liked to be in the policy end and work with the board and the top staff at Met. And he wanted me to run the legal department itself. And so that worked out very well. And he worked on the Purple Canal and things like that. he was good at it. So I just did legal work there. But when he left, then I got to see what he used to do, and I liked it too. So I hired Abbott to run the shop, only when during this trial, which was a couple of years or more. But whenever I was gone, I knew that Abbott was there, and we'd call in every couple of days, but or he'd call me if there was a problem. But there wasn't. I knew Abbott very well in the Attorney General's office, and I had complete confidence in him. So I was never worried about what was going on at the office. I was devoted to and concentrated on the trial, Colorado.
Tell us a little bit about the Galloway proposal. That was another Colorado River controversy during your tenure, Ashley, I think, as general manager rather than general.
Yes, I think I was, yes, so I was general manager then. I always took the position that the Colorado River available water was over allocated. In other words, they assumed more annual runoff than was the case. They based it on earlier years, and then they learned that, excuse me, they learned that they had overestimated, and so they have distributed more water by contract, the federal government did, among the states and within the state than was going to be available. Now, at any one time, not everyone is using all their water, and in any one year, you might have a good supply. And you could also, of course, keep a reserve, though that becomes debatable how much a reserve you have to keep under what conditions. So I lost the track of of your question.
The Galloway proposal.
Okay, so I had this position that Met had historically, that the water is oversubscribed. If you don't use your water, it goes to the next priority. The water in Colorado and California was allocated among the different agencies, with the agriculturalists getting the overwhelming amount of water. And even there were priorities among the agriculturalists or irrigation districts. So there was no water. There was no one else to give you water. There was no one else to put in a new person like the San Diego County Water Authority, who for a long time had shown an interest in Colorado River water, independent of Metropolitan. So shortly after I became the manager, San Diego representatives came in to see me, and I had Myron Holbert at the meeting, and they said they had been arranging with someone from Colorado to buy water from what was going to be called the Galloway Project. And the Galloway Project was essentially to use the White, I think it was the White River and Green River in Colorado, and to store water, build some dams, store water, create electricity with the use of that water by dropping it. And then that water that they released would be sold by contract. Water that they were going to release would be contracted for with San Diego, and it would roll back into the Colorado River. And San Diego would take it at a certain point. And we were just told this kind of like, oh, just hit us in the face. You know, it was a strange concept. We didn't know about it. And they were saying, we're telling you this morning. This afternoon, there's a press release on it. And Myron, had such expertise in the Colorado, pointed out some very obvious major problems with it. Apart from any feeling about metropolitan interest, just the law of the river as they refer to all the statutes and cases and everything else that affects water contracts, everything that affects the water rights of the Colorado River, they refer to the law of the river. And Myron would point out that politically, it's going to be very hard to take water from those rivers. The environmentalists regard that as untouched streams, or certainly they don't want it dammed, and you can count on that. But that's their problem to find out. But he said you have to question whether that's likely to happen. You can produce, if you produce electricity with it, that's fine. But as soon as the water gets into the Colorado River, it's Colorado River water. It's not earmarked. It's not color coded. It's Colorado River water. It's just part of the numbers that tell us how much water is available for all the people with contracts in the different states for Colorado River water. It's not San Diego's water. San Diego has no contract with the federal government. The federal government runs the river, and there's no contract with it. And as soon as the water gets in the river, it's whoever already has rights to Colorado River water. So we made that clear. Myron laid it out. I mean, it wasn't that difficult, but it was very disappointing. I mean, they said, well, we're going to do it. We don't agree with you.
Do you recall who was there for San Diego?
Well, I know Harry Griffin was there. I don't remember who else, but Harry was there, and I know maybe their manager was there, and I don't know how far back that would be. I don't know which manager. It would be for Lester West. I don't know if it was Larry
Oh, Larry Michael.
or the fellow that preceded him. And he was a very pleasant guy, but whoever it was, he was there. But it was Harry and I think another director who did the talking. Maybe there were 3 directors, but they had a contingent there, 3 or 4 people. Now I remember Harry, and they say, well, we know him, referring to Holbert. He wouldn't agree with us no matter what. I mean, it became personal. Myron was very adamant in his presentation that it simply can't be done. And their attitude was, well, it's not, whether it can be done or not isn't going to turn on your saying that. The trouble with our point of view, and at that point they were referring to Myron, they would say, the trouble with you, Myron, is you think the law of the river is etched in stone and can never change. All you're saying is a lot of things have to change to allow this to happen. And Myron just, his attitude was, you have no idea what you have to do. How many state governors and their legislatures are going to have to approve all of this. Now, the Upper Basin has had no interest in letting the lower basin have even more water. And that's what you'd be doing. And so there's huge political problems, practical problems, and legal problems. So it ended on a bad note. They had their press release in San Diego, and it was in the paper. It just caused us a great problem because the board, hopes that these things can be taken care of, and the boards don't like an open fight among agencies. We're all metropolitan. We want to be united. We have enough enemies on the outside that we have to fight. We don't want to show them we're split. We don't want to be split. So try to work it out, and the months went by, and I just said, well, I can work this out. We're going to be saying that water in the Colorado River can be earmarked for people that aren't ahead of us on a contract, indeed have no contract. And with the future being as such, we may have to rely even more on Colorado. And we just can't go as a matter of policy and ultimately a matter of water. And so we couldn't work it out. And I just went down to the authority and spoke to their board and told them why we're against it. Of course, I advised our board about it. I explained it all, and so I went to San Diego and I explained it all to them. They were, I think, primed not to hear us. Their attitude was always, well, here's Met again, just not allowing us, just keeping us constrained to Met. See, they don't want us to buy water elsewhere. They want we're their biggest customer, and they don't want to lose us. And so the points we were making, I don't think influenced very many people. Maybe 2 or 3 lawyers, others, but basically their delegation had gone over this pretty much with them because they were jumping right up at us. I mean, there was no the questions weren't in understanding what we were saying, but that why are we doing this? And I knew there was this because before we got on, without telling us, they invited another speaker, and he was a local. I think he was an assemblyman, but he was a local politician, well known, and he just attacked Metropolitan. All our work against San Diego, we haven't gotten new water supplies in 20 years. We lost the peripheral canal. I mean, he brought up so many other things that I didn't address them. I just said, well, there's a lot of I don't want to use the word blame, but a lot of comments could be made as to why the peripheral canal didn't succeed. But that's not why I'm here today. So I just stayed on course. But he gave his harangue and just left. I mean, and so I could see there was a setup where we're not going to be well received or objectively received. And so eventually I had to go to the board for a vote. And then 2 or 3 of the board members who I knew and respected greatly, they were lawyers. Well, they weren't all. One was an engineer, Hans Doe, John Cranston. They were real old timers, and they knew there was something wrong with what they're trying to do. But they said they're trying to get it handled. So could you give them a couple more months? And I said, sure. And came back and he said, no, can't do anything. So the board voted almost unanimously to fight, to take whatever actions necessary to stop that Galloway project. Galloway, I think he got $10,000 according to the newspaper when he first ventured the program to them. And then I think they didn't vote. They didn't vote when, I don't think the San Diego delegation voted, maybe 1 or 2 of them, but they just sat it out. And I think just 1 or 2 other members voted against what we were doing or siding with San Diego. But probably 85% of the votes supported the staff. And with that, kind of ran its course. Going.
As I recall, both you and Warren, I think, wrote very extensive board letters probably in anticipation of asking the board to take action on the topic, which are sort of almost mini treatises on the law of the river.
Well, I'm sure that Warren did most of the writing then, because he's a good scholar and writer. But we also wrote opinions. Warren wrote the latest opinion as of that time. Bob Will had authored an opinion before him. I mean, there must have been 3 opinions of men, all on the point that no one else can insert themselves. So maybe theirs didn't contemplate Galloway, but we were continuing with that same understanding of the law. And I remember once San Diego Council coming to see me and saying, you know, if you treat this metropolitan as not an urban area, mind you, or municipal metropolitan water district is metropolitan. I mean, that's not something that can be ignored. And he was allowing us to use water on agriculture even when there wasn't water. The reason I give this explanation or this example is on various things. San Diego just had the feeling that if the manager or general counsel would allow it, the board would go along and everything would be fine. And we were hanging things up. And I said on the agriculture, I said, well, agriculture, we can sell agricultural water when it's available, but if it's not, it has to go to metropolitan areas. So then they gave me a brief on how metropolitan includes agriculture, the word metropolitan. And I said, I'm not convinced. I mean, the way they were working is as if the top staff were the problem. We just gave our best advice to the board. I mean, that's it. We wouldn't be giving our best advice if we said, yeah, San Diego could do this. But we were not held in great esteem after that.
And as you
in
say,
San Diego.
I think Galloway just sort of
Yeah,
died of its own
Yeah.
weight or whatever.
yes, it did. They knew that metropolitan, of course, Arizona was fighting it right along. And so it went nowhere, but ultimately they got back to buying water from IID. I was gone. I've read all of this in the newspapers. And, you know, the Metropolitan took a more conciliatory position. You know, we have our rights, our Metropolitan has its rights, but you don't have to assert them. You can allow things to happen, and it seems to me that under the manager prior to the current manager, under his regime, we apparently Metropolitan, I say we, Metropolitan apparently has agreed to IID selling the water to San Diego. A major change in position, but that's where it is. I don't know if that's happened. I don't know if there's legal problems still out there or what, but I know he didn't say he was fighting that. And that's the kind of thing that went against the legal position, the long-standing, decades-old legal position of Metropolitan and Coachella. Coachella used to fight that. I don't know if Coachella fights it anymore because I think they may have made their own agreement with IID, assuring its water supply, so wouldn't care. So, I mean, I'm off as of 93. So everything after 93, I read about these papers or material sent to me from it.
As you look back at the work you've done on various Colorado River issues, what would you best want to be remembered for? What do you think is the biggest achievement?
On Colorado matters, it would be conservation. Whether it's conservation by lining more of the older canal, and in particular, it would be upgrading IID system. I mean, that concept is not inconsistent with the sale of water. You should do that first. Stop the waste of water, inefficient use of water at someone else's expense. See, because you have these priorities, that why should the fellow IID in front of Metropolitan care if he's using more water than is necessary? It's not coming out of his hide. And that's why Metropolitan would pay for those improvements. But if you think through the long run, we were really in a tight spot. I think a court would order IID to make improvements because it's wasting water. And if it didn't, it would probably forfeit part of its water. I mean, if you know the law does react to circumstances. If we're getting into an urbanized life with large industry and loads of people, and they're wasting water there, well, the courts and you know you just nail it down when you say, and by the way, we're willing to pay. We don't have to. You can sue someone for wasting water if it's hurting you. You don't have to pay for whatever the needs are. If there's reasonable things that other person can do, well, we went beyond that, and that wasn't enough. So I am still pleased with the breakthrough because that was the first additional water supply, and the approach was so good. I say it became very popular in articles, but I'm sure they had their problems like this everywhere. It's hard to get a person to give up a water supply. They worry about it. Even if you say, we're not changing your rights. So I'm most pleased with getting more water for certain for Metropolitan insofar as Colorado River matters are concerned. And secondly, I'd be very pleased with the Supreme Court decision, but that was as a lawyer, and I'm influenced by the fact that I got a lot of personal gratification as well as helping Met. So I like the breakthrough in IID, though apparently it didn't break through enough because there should be more contracts like that.
Is there anything you regret? Any issue that left unresolved that you wish you'd been able to solve?
I don't have a regret in that sense of identifying an issue that wasn't resolved, but I did have long-term thinking. If things got bad enough, you could get in a position where you refer to California's priority for urban areas for city municipal use over agriculture, and you start pressing that and saying whether those contracts have to be changed. Metropolitan went along with those priorities. They weren't, they weren't inexorable. Granted, they had earlier rights under California appropriative rights, law to water, than we did. But I don't know under the federal act that the federal government had to give them those priorities. Met went along with it. What if we had argued at the time that the municipal use has to come first under California law? What if we argued there was no priorities? there were things that I was thinking through at times that if the situation warranted it, there are a lot of other legal approaches to take, but we're always willing to avoid being put in a position of a bully or anything like that. There's no newspaper can write metropolitan without the word giant in front of it. I mean, that's one, it ought to be on our letterhead now, because that's the way they write it. It's Giant Metropolitan Water District. So everybody is sympathetic for the farmer. The farmer's using an immense amount of water. Colorado River, 3.85 million acre feet, and we get 1.2. And yet sympathy is all would be for the farmer. So there are, it never came to pass, but I certainly had other approaches if it were necessary, whether you win or lose, and you take them and you worry the other fellow, and then maybe you settle, and maybe he accepts money to repair his system, or he sells you water if you're at a level where you've met reasonable conservation standards. So I regret, in a sense, never getting to those points, because they were intriguing points to me. Whether they would have succeeded, I don't know. No, I think I loved what I did at Metropolitan, whether it was Colorado or the state project. My disappointment would not be over the Colorado River. It would be that the state project has really not moved. Maybe CalFed will do something, and I was in the prior incarnation of CalFed, and it took a long time, and I didn't see a lot happen. But Tim Quinn is a very, very capable guy, and he feels optimistic, so I'm pleased with that. I like the internal things, our own conservation, the way we work with other member agencies and cause them to conserve water or to reclaim water. I mean, we've done a lot. We've been pushed by droughts, and we had excellent staff people with a lot of imagination and just excellent people.
So what would you like to be remembered for, just overall?
Oh, probably looking at the big picture and appointing the right people and to handle problems and keeping out of their way, and being a good conduit of information, a good communicator to the boards. The board would support us. But I was very worried about being a manager, because dealing a lot with engineers, and they had a lot of ideas that they were bringing from the past, where to put the middle reach of the state project, or the foothold, the foothill feeder, those alternative programs to get more state water. And I could see, because I wasn't an engineer, and because I wasn't here at the time for 20 years or more past and didn't know all the history, I'd ask them questions. I'd ask a lot of questions. And that caused a lot of them to think things over. And we start changing a lot of things. Metropolitan used to be kind of not well known. They did something, and then it lasted a long time. They're out of the public life. That all was changing. Environmentalists were no longer the subject of humor. They were at Met even after they weren't in the public at large. Met was behind the time. I got to Met, and a director said, "You know what the definition of an environmentalist is? The feller who built his cabin last year." And I thought it was funny too. But you see, you don't hear that. That attitude isn't here. The public won't support it. So you have to. So Diamond Valley Dam. It's another thing that I say, if you want to pick out things, I very, very pleased that we were able to just think that up and get it going. And now it's pretty much done. Doubling our storage in Southern California, the only dam of that size built in the country in the last several years. And we did it by working closely and in advance with environmental organizations, with all the government regulatory organizations, whether federal, state, local. We got everyone to buy off. It was a good project. We had to make them see that, and then we had to offset things by buying land, dedicating it to conservation, and in that way, we add a lot of storage. California, when the water is plentiful in the north, we wouldn't have anywhere to put it. So now we have somewhere to put it. There are years where it does go out in super quantities out in San Francisco Bay. So I'm pleased with that. Colorado, I was I'm pleased with a lot of things. And my disappointment is that the state project really changed much. And we put a lot of time and effort there, getting to know all the people involved, particularly the environmentalists. And I wasn't able to reinforce much.
Well, as you pointed out, when I think back to the years that I was fortunate to work for you and with you, just an enormous amount of accomplishment, and being at the center of so many issues. I mean, I know you mentioned that your oral history with CVPIA has been done, which is, I think, a testament to how influential you were and important to those discussions you were. I mean, I think your oral history of a lot of different things could be undertaken. Actually.
Well, Quinn and I organized urban groups, north and south. So you no longer had the north-south split, which always troubled any water coming from the north. There was the north-south split in cities, in districts, the population generally. So on the Central Valley project, we organized the urban groups, San Francisco, Sacramento, everybody. I'm not sure Sacramento because they're so involved in farming but we got loads of cities up north and south. And so in Washington, they paid a lot of attention, big population, all these cities. We had a lot of their representatives. So by doing that, we came on very strong, and we hadn't been able to do that in the past. If you just went to Southern California, you didn't have all the support you needed, and the farmers always could get Southern California farming support. You know, the Central Valley could get IID and other farming areas and their representatives. So that was an exciting thing. I think I finally say that I didn't have a huge program when I became manager. I just looked at the problems and directed myself and the staff to those problems, just as they happened, as we learned of them. The very first problem was whether we're going to support the East Branch enlargement. It's a state project, but we're going to pay for it, or stay with the middle reach of the Foothill feeder. Our top staff was divided. Most of them wanted the Foothill feeder. Why? Because that was part of the original plan of how the district. Well, now look to see where the houses are being built, et cetera, et cetera, et cetera. Look at the costs. I mean, Holbert and Balzerzak were two of the assistants, and they were extremely helpful. They just showed me the cost of each, and that there's little likelihood that the Middle Reach Foothill feeder was part of a a program where we assumed we get all the water from the state that we contracted for. Well, that was looking less and less the case, and you would be building a more expensive system. And you would have to get some houses, you would have to condemn some areas. And so it just seemed very easy to me that we can't count on the water, so we don't need that big a system. It's more costly. We'll run into some housing, and that makes people and their representatives unhappy. The other one will do the trick and has. So sure, you could say now this is 20 years later, maybe the other one would have been better. But at the time, it hadn't been addressed. It was just put off year after year after year. And finally, when I got to be manager, the engineers was telling me, no, we got to really do something about this. It can't go on because there's lots of times when there's lots of water. We have no way of getting it. So Kennedy was eager. He was then the head of the Department of Water Resources. He was eager to go with his program, but it was up to us because we were going to pay for it. So he just said, I wish you guys would make up your mind because it has to do with how many people I have in the budget. And so I said, he's right, we should make up our minds. And we did. And that's the way everything happened. We should encourage member agencies to reclaim water. Well, it was too expensive for them. Well, we'll give them the difference. We'll subsidize it to make it go. And then that start to grow and more, put it in, and then changing the water prices so that you would take more in winter and store it, and you wouldn't pay the higher price in summer. And these weren't my ideas. I mean, I'd hear them from people, and they made sense, and I would test them, and then we'd go, and then I'd usually talk to the board, or I'd have one of the engineers explain it. And so I'm simply most proud of tackling the problems. Just not, I just wouldn't let a problem slip under a rug. The fun was handling those problems. Really exciting.
So if you have any parting words of wisdom for people, particularly, I guess, those still working on some of these very difficult Colorado River issues. I mean, there seems to be a settlement in place, but there's lots of implementation issues and frustrations now and then, I'm sure. About
You refer to a settlement with the other states,
Well,
or are you
well,
just
amongst the
referring to
California agencies, but also involves the other states because of their cooperation
Yeah.
on interim surplus guidelines and things like that. But do you have any final words of wisdom?
Well, it's difficult because you're already at a place where I might have wanted to argue a stronger position for Metropolitan. Like I read in the paper all the time, and the way it's put, Metropolitan has taken more than its share. You hear that all the time. And now we promised to live within our share. We never took more than our share. We always had the right to take the excess water. We couldn't take it unless the government released it. Our rights are to more than the minimum. And no one, I could read in the papers, no one urging that, no one making the Times writers understand that. So it was finally Met's going to be a good boy and do the right thing. Well, that takes away from your position in negotiation. So once you admit that, then what do you have left? See, that was I'd surely negotiate, but I'd negotiate from a stronger position. So I came into Met and it was at a certain position. Anyone that's there now is at a certain position. There's no point in saying, I wish it weren't so. You look at what there is today and you do your best for Met. You're working for Met. Now, there was a director that told me personally, Carl, I've always thought highly of you, and I think you did a wonderful job for Metropolitan. But what I didn't see is you're a Southern California leader, not a statesman. And I'd say, well, what does that mean? And you didn't look at the whole state. And I said, happily, there were loads of other people looking for each part of their pie. And if I did that, all that would do is raise the ante. See, if I'm looking out for you and I say I'm only going to ask 10 and not 20, see, that they say, good, you ought to get 5. See, I mean, you can't, and I said, and I'm paid by Metropolitan. Now, I will look out for the whole state to the extent that it furthers Metropolitan's interest. Lots of times you have to do that. You simply have to pay a lot of money for something the governor wants to do. And yes, it's helping mostly up north, but you're getting some credit for something. Sure, that's different, but you can't, I mean, I just felt I could not assume that I'm going to do whatever in the interest of the entire state unless it was consistent with Metropolitan's interest. So that's what I have. Do your best job for Metropolitan.
Or whatever agency,
Or
I guess you
That's
represent.
right, and assume the other agencies have people looking out for themselves, and you'll be surprised how you can find that it works out. Well, you can do well for both.
There will be some common ground.
Yeah.
Well, Carl, I want to thank you very much for your time. It's just been such